money. And the best way to look at it is even in that court process that we keep referring to. Lawyers have been accused of being greedy, and especially when it comes to matters of estates and the deceased wealthy people. You see that then the estate then loses a lot of value due to money going to professionals who really are then just performing a role after the fact because you didn't put in a sound plan in place. Likewise, as the court process is not instant, you may have urgent needs for school fees or healthcare of your beneficiaries. And if you've not put in, say, some form of provision, again, you will be forced to go to court, seek limited access to those funds. And that, again, you're spending time when really, if a plan was in place, it would kick in immediately. Now, likewise, if you're not able to put it in place, it means that debts or other issues will creep up on your estate, and the ultimate asset passed to beneficiaries may not be sufficient. So what are we saying here? We're just saying, put in a plan in place. It will save on time. It will get you to where you want your beneficiaries to be. Now, again, if you do not plan for taxes, you will find yourself having to incur a huge tax bill. For those who are wealthy, they plan their tax affairs very keenly. They make sure they only pay that which is necessary. So they maximize and optimize their tax liability to only that which they need to be paid. Now, how do you do that? One, you put assets in certain assets and vehicle classes that the transition then from you or where you control is moved without any need to pay additional taxes because they are not earning or getting new benefits. So in which perhaps we will demonstrate even in trust, if assets are held in trust, it just means whenever you change beneficiaries, they don't incur changes in, say, payments of stamp duty or having to incur additional tax liabilities because I have moved the asset from one person to another. You may seek to also get consultants who advise you in terms of tax. That way, as you structure your plans, you make sure you're paying what is necessary and what you cannot avoid. Finally, I know each one of you may know of this. You know a family member, or you've had your neighbors, or if you know someone who, upon the death of the patriarch or the matriarch, the family then really broke. People chose to pick their assets and have not been speaking with each other. They choose to actually fight because perhaps they feel the head of the family did not take care of them or was discriminatory in the apportionment of the estate. Now, if you put in place a plan, means, and it starts operating early, you will retain the family bond because the need to fight for assets is not there. Each person is catered for. And even in the unlikely event that perhaps you have an unborn child, there is still that uniform bond within the family and everyone is actually provided for. You, in these plans, you are also able to provide for, perhaps you have older children and very young children. They may not need, your older children may not need support, but your younger children are still your children, and perhaps you need to take care for their educational and wealth and healthcare needs. So with a plan, you're able to extend and perhaps plan for everyone based on their circumstances on their life journeys. So here really are the benefits. It applies to all of us. It means that then it is a compelling need for us all to put in a plan in place to make sure we avoid this. Having a family fight over estates is not something that should happen. People should remain united and the wealth should not be separated to us. So we've told you why. Let us tell you how. So the how really is then the steps you will go through just to make sure you have a plan in place. It is a process and it is something you can do now, and it does not require you to be wealthy. You plan with what you have now as you accumulate more. And even as you plan, it is just an item where it is always relooked at on a continuous basis. So where do you start? You start with counting what are your assets, making an inventory of all that is yours, all that perhaps you owe others, or all that perhaps you will acquire. You list all the known assets that you have, and you think through how these assets can then move to your beneficiaries. So the next bit is choosing who is going to benefit from those assets. You structure it based on your desires. You seek to move it, obviously, to them at the lowest cost and at the least taxes applicable. So again, once you've chosen your beneficiaries, really it's to get it to them. Now, your beneficiaries here do not only limit you to family members, friends. You can move it to charitable organizations or causes. You can move it to even corporates or even a trust, so that then the transition really is just sequencing it from one step to another. And as you choose your beneficiaries, you seek to apportion what they will get. So if we try and see, we can move to the next slide. Okay. Now, we know you are here today because you're a Britam customer. We are encouraging you to also, as you plan for your estate, you will come back and revisit your pension and insurance plans to confirm who did you name as a beneficiary. We encourage you to continuously update your beneficiaries due to any change in circumstance. You have a new joiner, and perhaps you have become a grandparent. You wish to make provision for your grandchildren. All that is within your plan. Now, once you've just then established who are your beneficiaries and you've reviewed that, you will seek to then now codify it or document it. There are various forms in which we had then perhaps touched on, where you will put down your wishes. Your wishes may be put down in a will, a trust. You may put it down in the power of attorney. You may have given a gift. All this is a form of just documentation of your wishes. Now, as you document, really, it is just to say what will happen to the assets or the payouts. Now, we always encourage people to revisit those plans on account of you may have acquisitions of assets, you may have new family members. As the changes come in each year, keep reviewing. What we are pushing today is annually just revisit what's your plans. Who did you give them to? Did you acquire new things? Did you dispose of other items? What is there in your plan? Now, finally, not everyone knows it all. You will always need consultants, financial advisors, professionals to guide you in terms of the structuring of your plan. And the plan really is where you place your assets, where the assets then are able to move from yourself to your estate, how they are housed, how they are then managed and operated. Now, the professionals we are referencing here are, one, obviously your advocates in terms of drafting of wills, trusts, your accountants in terms of your affairs, knowing where your earnings and where your money goes, tax advisors in terms of what is your tax liability, how do you ensure that tax liabilities are actually paid for, and also other financial advisors such as Britam, where we tell you in terms of trusts and the structuring of your products such as insurance and pension. Now, the professionals here really are applying their subject matter expertise to help you document or express your plan. It is you really who paints the picture. It is not the professionals who paint the picture. They just are meant to guide you in putting it in place. So, wills we will discuss, and perhaps we'll do it also from a comparison, but we've referenced trusts, and perhaps it's a good time to bring it to picture and to your appreciation what a trust is. A simple definition then of what a trust is really, it's a legal relationship of three parties in one form, the guarantor or settlers. Two, you have a trustees, just like in pension schemes. And three, the beneficiaries, just like you have in pension schemes and your annuity products. So these three parties really perform what is called a trust. The trustees then perform a fiduciary role on the benefit of the beneficiaries. They undertake certain investments and certain decisions for the ultimate benefit of your beneficiaries. Now, if we look at it this way as just those three parties, then you sit in as a settler or grantor of the trust, you put up the trust, and you do so that while you are living. You will then seek to nominate and appoint a trustee. The trustee here may be an individual or a corporate entity, for which then perform that role, which is the fiduciary role in terms of the management and investment of the estate or the funds that you have put in place. Your beneficiaries will vary. They may be your parents, they may be your spouse, they may be your children, maybe your grandchildren, your family, or any person who has benefited from you. So, having at least put in place that definition of what trusts are, let's just make a comparison as to why perhaps you are always told to put in a will. Does it achieve the intended goal? Perhaps, yes, it does in some form. In others, perhaps it is limited. So the distinction really, when you look at a will and a trust is, yes, a will may be simple in the form of, it is just a codification of what is your desire in terms of the distribution of your estate. It is simple in that it is just, this asset is identified and it is then moved to a named person. Two, even in a will, you will seek to say how your body may be interred. You may seek to say what becomes of certain assets if you wish them to be for a charitable cause. You seek to then name people, and in this case, the limitation is they must be living individuals. There's the extent that then you perhaps may seek to extend it to unnamed individuals, but really there you're taking a chance. The other limitation of wills is that they only take effect when you are not there, meaning you have now passed on. The instructions then now are effective. Your executors then draw authority from that point. They cannot take authority before that point. Now, wills again do not help you if you're incapacitated. God forbid you end up in a position where you're not able to manage your affairs due to perhaps a prevailing condition. The will does not state what happens to you. It only comes in place after you pass on. So perhaps this is the solution we want to direct and guide people towards trusts, in which case we are saying trust can be either private or even trusts offered by financial organizations. Now, trusts in that context they are more detailed. They will speak towards one, movement of assets from one person to another. They will seek to express the management and running of those assets. They will seek to even name unnamed individuals. If you wish to move an asset to the second generation of your family, you can do that. Likewise, in this bit, it's a bit technical. It means it may involve more professionals than just lawyers and accountants. You may have even from trust, estate, and property management, in which case you assign an expert to run the affairs of, say, your apartment block. In some form of manner, trusts normally really are private. They do not expose your estate to scrutiny. In a will, your will has to be read. It means then your estate will be known. With a trust, only the beneficiaries and the trustees know your full extent of your estate. Third parties will not be able to have the benefit of knowing what is the extent of your estate. It can be used in those instances of now you've been incapacitated. Within the trust, you can make provision for insurance to be paid out for and cater for your medical and healthcare needs. So really trusts is something that is way beneficial compared to wills. Sorry. So we continue into looking at then what can a will do and what can trust do? What is the offering that perhaps is having us in this session? Perhaps let's start from the bottom. Court processes are always there. Even in trust, you have seen prominent families being dragged into court because perhaps beneficiaries are not happy as to the distribution of the wealth. But rarely do you see then that trusts are then being collapsed or closed on account of the court process. It is a directive of the beneficiaries. But wills will always stand for contestation in the court process. And you always, and as what we have said, the court can step in where you have failed to make provision for a beneficiary who was entitled to your estate. Now, again, we were referencing your health and medical care. Wills are limited. We said they will only step in after you've passed on. Now, if you set up a trust now with the intention that perhaps in your sunset and later ages, you anticipate that you will require intensive medical care, you can put in place that the trust will take out your covers for insurance. It will perhaps make sure that you have nursing care if necessary. Again, education is only possible if it is on a regular and a structured manner. You may designate perhaps a person to receive a lump sum payment on death during your drafting of your will. But really, are you taking care of the educational needs of your children? Wills are limited in that you indicate that the person perhaps will receive the money. You may desire that the person, express it that the person should pay for the educational needs of your children. Can you force them to dedicate and transfer the funds to an educational institution? With a will, no. With a trust, you will be able to direct that then a portion of the funds should go towards educational. And even if you wish to, you can actually put a trust for the sole purpose of the educational needs of your children. Likewise, the trust can come in place and then support you in terms of providing care for your perhaps elderly parents, surviving spouses, or your children, or even if you have a person with special needs, how they will be taken care of. Again, because a trust is put in place while you are alive, you extend its mandate of a period of time, in which case then, as long as there are funds within the trust, it will take care of your family. Now, a trust perhaps unites a family when you compare it to a will. A will distributes the estate, and you have seen many a case where people, upon the distribution of the estate, they relocate to other places. They do not speak to their family members. And really, the will then is not achieving the goal. If your intent is to maintain your family together, you put a trust, you name them all as beneficiaries. They continue to benefit from your estate as they are one. You can direct behavior because you can say then the trust would only pay out if they remain together. A will may not have that extension in terms of your mandate. Now, you may seek to maintain certain assets within your family, and you seek perhaps to jump a generation in the distribution of your wealth. A will may not fully achieve that, but a trust can, in that if you have created, by way of example, a family trust, and you have all the family members within that trust, you move the assets within the trust into one, and they are able to benefit as all family members. You are moving the asset from one generation to another. As you move it from one generation to another, you're also avoiding unnecessary costs, as perhaps paying stamp duty, perhaps paying lawyers to help you in the movement. All that is just making sure that the asset remains within your control and within your estate. Now, again, even with trusts, you're able to perhaps move the assets to your spouse without much hassle. You're aware, perhaps if you have joint ownership, perhaps in certain assets, moving them from one side to the other side of the family is a challenge. But with trust, the transition is quite easy. Now, you choose the person, again, who sits in as a trustee. And that is, again, possible within wills where you elect who are your executors. But even with the executors, they may not perhaps survive your beneficiaries. So trusts perhaps are unique in that if you nominate a corporate entity as a trust, as your trustee, they are able to then perhaps outlive your 2 generations. And that then really is giving you a structured way of how you're administering your estate. If we just look at it, then finally, in terms of the other advantages, if you want to gift your children in the most optimal way, trust perhaps is way beneficial compared to what you have within wills. Again, I have referenced it. Skipping generations may not be possible within wills, but if you look at it from a trust point of view, you can name unborn children to be the recipient of certain assets and maintain them, perhaps even for charitable or good causes, meaning your legacy will outlive you if you put it in a vehicle such as a trust to proceed and then offer what is your legacy to society and your family. Now, if you put up a trust, you'll be able to ring-fence it from creditors and perhaps other people's claims on your estate. The trust will not form part of your estate. It is a separate legal entity in itself for which beneficiaries are named. And that trustee then performs their fiducial role to make sure that then the beneficiaries are protected. Your estate is then not free from creditors' claims. So if you have debts, it would be perhaps in your interest to set up a trust, in which case you're able to hive off your assets from one side to the other. Now, perhaps there are some who may be seeking to safeguard themselves from divorce. You can seek to mitigate the distribution of your estate in events such as divorce or where you have former spouses. And you can also make provision for former spouses, both in wills and trusts. I had referenced then really cooperation is only possible within a family setup where they are working together perhaps or are being provided for within a trust. So wills really, and you've seen it all, distribute the assets, you've also distributed the family. Now, trusts are also flexible in the nature that perhaps you can structure payments to be on anniversaries or when perhaps your beneficiaries achieve certain milestones or goals. You may elect to pay out a certain portion of the estate when your children or beneficiaries attain a certain age. When they perhaps end up getting married or perhaps they get children, you can structure your payouts in such a manner that, one, you're rewarding your children on an anniversary. They will remember you for that. And I can tell you, really then, trusts really are offering a flexible option to everyone as compared to a will. So let's bring it all home. Estate planning is not for the wealthy or those perhaps close to death. It is for everyone. It is done now, the omnipresent now. It is for you to think about it in terms of how do I extend my legacy? It does not require you to have a lot of assets. It has options in the form of the plans that we have provided, wills, you have trusts, you have power of attorneys, you have the option of putting in insurance and pension plans all together, working as your plan. All this is with a view to really safeguard your beneficiaries. Now, today's session, really, we were pushing the agenda for trusts. And that's why we were saying wills really are limited. Insurance products and pension products are limited. Trusts give you a way to extend your desires as to the affairs of your family and the management of your estate to a longer period, you can seek to put in place a private trust, such as a family, a charitable trust. You can put in or get a trust being offered by corporate entities. And we as Britam will be soon coming to you with an offering on trust. And all this is really to give you some sense of control and determination as to how the wealth and estate of your family will be run. So I wish to then perhaps bring to your attention October, as much as is Breast Cancer Awareness Month in Kenya. Even in the month of October in the United States of USA is the National Estate Planning Awareness Month. They are planning, and this month is really taken for planning of your affairs. So here, as Britam, we are encouraging you, start now. Start planning. If you do not have something in place, start planning. If you have something in place, consider what we are offering, trust and other options for you to structure your estate and for the benefit of your beneficiaries. That way, we as Britam will be here working with you in this life journey. Thank you.
Thank you, Jackson, for that impactful presentation that you have done. Thank you for providing us with a guide necessary for us to ensure that we are well prepared for any potential transitions. So this has been an awakening call for all of us. A few lessons here and there to learn and implement in our lives going forward. So key points that I have picked up from the conversation that we have had is, let's not allow the government, let's not allow our clans, let's not allow the people that we did not like to take control of our voices. So it's very critical that then we need to develop an estate plan. So for a majority of us who have financially independent children, there is nothing wrong with giving your children a stepping stone in life. So please have an estate plan in place for them. So did you know that people's personalities change when money is involved? I know in the African society, a lot of us hope that our sisters, our brothers will come through for us when we are not there. But this is not the case. We have many realities to look into in this world, where families have been thrown out into the streets by the same siblings that we entrusted with our assets, so that because they want to have access to what we have worked hard for. So it's very critical that we think about how would we want our estate to be managed into the future. Another lesson for me has been, I have always thought that estate planning is for the wealthy, for the elderly. Kumbe, this is meant for everyone, even the young. As long as you have anything that you call yours, then this is very critical for you to take. We need to take action to ensure that then we have peace of mind. So the other thing that I have learned, I think those are the key highlights for me from the presentation that has been done by our legal manager today. I would like to appreciate the joiners, the attendees who are joining us from the various locations. We have Frances, Rose, we have Ruth, Lucy, Titus, Geoffrey joining us from Nairobi. We have Moirori joining us from Nakuru. We have Penina joining us from Ruiru. We really appreciate you joining us today. Even for the rest of the viewers, we really, really appreciate that you took your time to join us for this forum. Now we would like to get into the Q&A session. I note a lot of activity through the chat box, through Q&A. There are a lot of questions that have come through that we are going to address during this session. In the event that we are not able to address all the questions, then we shall be reaching out, we shall be sharing the responses to those questions that we are not unable to respond to today through your email addresses. after this session and including the recording, as today's session is being recorded. So we are going to take a number of questions, which I'm going to assign to the panelists here to be able to respond to them. So we have one question coming through from Eunice. Eunice is asking, what happens when beneficiary passes on after one's demise? I'm going to hand over this to our sponsor representative, Martin Oloch, to respond to it. Martin?
Thank you, and thank you, Eunice, for the question. So what happens when the beneficiary passes on after one demise? So we do have, let me call them two sets of products, where we can be referring to the products that are majorly managed by trustees or corporate trustees. And those includes the various schemes that we currently manage. And it also includes the income drawdown product. So for such instances, if the beneficiary passes on after one's demise, then the issue is referred to the trustees to investigate further on all the dependents of that particular in that particular account, and decide on who is supposed to get the benefits. So technically what happens is, if the beneficiary, for one reason or another, was either not nominated or the beneficiary passes on, then the decision on who will get these particular benefits is referred to the trustees of the scheme. We also do have our life products, which also covers for this particular issue. In that regard, it provides for an option of a contingent beneficiary. So technically what happens is, if any of the beneficiary passes on, then the benefit is meant to be distributed to the remaining beneficiaries. That is, if you had nominated more than one beneficiary. However, in an instance where there is an unfortunate death of either the only beneficiary who was nominated, or all the beneficiaries for some reasons have passed on, then the benefit is now referred to the contingent beneficiary. If it happens that the contingent beneficiary is, for one reason or another, passed on, then this becomes more of a court process through the law of succession, where whoever who claims to be a dependent is allowed to seek redress from the courts through a letter of administration or any further process that the law provides for. So that, I believe, answers the question that has been asked. Thank you, and back to you.
Thank you, Martin, for that. The second question is from Frances. How comes that in recent times we have seen trusts not deliver the expected benefits you speak of? What, for instance, was the problem with the Karume trusteeship? So I would like to hand that over to Jackson to be able to respond to us.
Thank you. I think the answer is actually in the question. The issue was the trusteeship, but we are not here to cast blame on the trustees for the Karume's trust. But perhaps let's take a step back. Part of the wealthy families, and perhaps in Europe and other developed markets, you will find that their wealth is held in trusts. They do not then perhaps hold assets in their own names or companies. They have held ownership of even companies in trusts. Now, just to bring it home as to perhaps what we want to provide as a solution to what we saw within the Karume's trust setup. One, the issues that were plaguing that trust were the costs and charges that trustees were charging, for which then the beneficiaries really felt that there was no value being derived from their role or the performance of the trust. Secondly, the individuals again who are selected as trustees were, for lack of a better word, the deceased's close friends or associates, people perhaps who would have, one, not always the best interests of the beneficiaries. And it came out very clearly when you saw that then there were beneficiaries who are lacking medical need, yet the trust had the funds, but the beneficiaries and the trustees were at loggerheads. Now, the solution that we are offering is, one, you look into setting up either a corporate trustee or a financial institution to stepping into the place of they are in. And in such really then arrangements, you also seek to lock in what is the compensation of the trustees. Typically, for such trusts, you will find that then the trustees earn a percentage of the value of the estate. If you take an example, that the estate is worth, say, 2 million or 5 million, you express it as either at 0.01% of the total value of the estate, meaning that then the trustees don't earn anything more than that. The balance then goes towards really the beneficiaries. And again, if you have professionals running that trust, you'll be able to make sure as trustees and true as beneficiaries that everyone is held accountable to it. So really, if we were to answer that question, is to say it is in the choice of the trustees in terms of individuals, the personalities, and the one lack of clarity as to what was really the earnings or due compensation for the trustees. Thank you.
Thank you, Jackson, for that. We have more questions. Geoffrey is asking, are there thresholds that should inform your choice of either a trust or will, e.g. size of the estate, etc.?
Thank you. Now, in this conversation we are having, we wish to state that it does not matter the size of your estate. Whether it be right now, all you are looking at really is you have a salary, you have perhaps a pension paying you. It does not matter the size. What is the guiding principle under this is, one, a will, and for which we are also still encouraging you to put down a will. But as you do draw your will, you plan and structure your will in such a manner that you will make provision to move certain assets perhaps under the will. You will seek to put some assets perhaps in insurance and pension and your annuity. You will move them that manner. You have other assets and perhaps real estate, movable property that you can move within the trust, keep it there. You retain control of the operations of that asset. It, again, will be able to transcend, even if you are not there, it will continue to operate in your absence. So you know that those items you'll be able to move within the will, they are those you'll put in the trust. But our underlying message today is that even in the insurance and pension, it is free for you to name a trust as a beneficiary. So what does that mean? It means that at the payout of an insurance, the insurance company will pay the trust. Under the trust, you've already named the beneficiaries. If you already indicated under the trust the distribution of the proceeds of anything that gets into the trust, again, you're providing for all your beneficiaries equally or to the proportion that you desire. Again, the trust will be able to extend. If you intend to pay for the educational needs and healthcare or welfare requirements of your children, the trust can have then a standing mandate to pay either into institutions or pay into organizations, making sure that perhaps your beneficiary are only drawing down the funds and not seeking to access a lump sum. So really, our message today is to say, don't think about the threshold. Take it as a tool. It's an additional tool which you complement your will. You look at your estate as it is, and potentially as it grows, complement it in the form of combine all these options to make it your estate plan. Thank you.
Thank you, Jackson. Very good questions coming through from Geoffrey. So he says, we sometimes hear of joint tenants and tenants in common in property rights. Kindly advise the difference. Please address the above question in light of drawing wills or trust. Over to you, Jackson.
Thank you. Now, in law, you can hold property jointly. Perhaps it's in the form of how you acquire the property, or you seek to have it, say, held because you are related in one form or the other. either by spouse or blood. So really joint ownership really and ownership in common are distinct. They are legal terms. Normally joint means that then perhaps when one person then passes or predeceases the other, they then really do not then have an equal distribution in it. When you look at it in common, it's that everyone there has an equal share in it. So what then normally happens, the distinction you will see at times is that the successors of the person who predeceases would normally come in to take over the property. But in common, you'll see that then the distributorship then just reduces the share. So as regards to then you trying to draw a will in that regard, one, in the will, you may seek to address where perhaps you had joint ownership, how your ownership will move. But that does not then always operate in simple terms. You may find that then because the other side of the ownership may have rival interests, in this case, it is for you to seek to determine what happens. There are limitations. It means that perhaps you may need to sell off the property first for you to get a portion or the equivalent value of that property for it to go to your beneficiaries. So when you are then setting up wills or putting up a trust, you think it through ahead. You say, perhaps this joint ownership or common does not benefit my beneficiaries. So you seek to move certain assets into the trust where already the beneficiaries need not to change. They will benefit from their asset without them perhaps needing to sell off or distribute it in the first instance. Again, within the will, you will have, as we guided, you will have identified all your assets, you will have itemized them, you will seek to distribute them in different form or manners. So as you do that, then you'll know what is well distributed under a will and what perhaps needs to be maintained under trust because you need it to extend perhaps into the next generations. Thank you.
Thank you, Jackson, for that. We have a question from Tom. So Tom says, please comment a little bit more about tax exempt and tax advantage transfer of property. Jackson?
So I am not seeking to be your property expert, but after this session, you're always free to consult your lawyers and other experts as to how best to hold some of your assets. Perhaps let's start from the Kenyan perspective. We hold or own companies which own certain assets. You assume that then that you holding those assets in a company is a tax efficient way. I wish to advise, no, it is not. In the form of one, if you seek to move the asset from the company, all taxes are actually due and payable. Two, or perhaps let's contrast it when you hold it under a trust. Now, in the trust, you will have moved the asset into the trust while you're living. So the ownership of the assets is the trust. So call it Britam Trust by way of example. So your beneficiaries are already named under the trust. So the asset needs not move from one entity to another if it's already in the trust. It means then perhaps if we are talking of any proceeds that then may come from the operations or the management of that property, it goes into the beneficiaries, meaning the trust receives the if it's rental income or whatever proceeds, it seeks to distribute based on your desired instructions. If you look at it from the point of then a will, if then, as we were explaining, you need to dispose of the asset for the beneficiaries then to get benefits or payments from the sale of that asset. It then means that really you're forcing your beneficiaries to first sell, in which case pay by way of example, stamp duty in the sale process, or in the other instance where capital gains, perhaps your property has gained value, you're incurring that capital gains tax because you're selling off the property. But if you move it into a trust and you don't need to sell off the property, you're able to maintain control of that. So you're avoiding paying potentially one, capital gains if they have an appreciation in value of your asset at the disposal point. Also, on this other side, stamp duty, and potentially income tax, depending on your advice on structuring of your entity. So not limited liability companies have its limits in terms of how you get taxed. So the advice we were saying is you will get in your structuring of a trust, you will have perhaps a tax consultant who will tell you how you will make sure you pay the minimal or lowest level of tax. Thank you.
Thank you, Jackson, for that. Last question that we have, how do my loved ones know about the existence of my estate plan in my demise? Where is it kept? Jackson?
Okay. Now, remember, we will look at it in two forms. Within the will, you have your lawyer who's acting for you in the drafting, and then they proceed to store and retain your will. Typically, it is just not your lawyer, it is the law firm as it is. They will seek to, in that instance, then on the knowledge that you have passed on, they will seek out your beneficiaries. Typically, you will find them, obviously, perhaps they will attend your burial, or they will show up to the family thereafter. They will declare that they have your will, in which case they will then pronounce and declare what were your desires. It is a process in which it is recorded, and for which then all your beneficiaries will be disclosed your wishes. On the flip side, if you have a trust and you have nominated and appointed a trustee, it is the trustee's obligation to seek out your beneficiaries if they are not aware of the trust being put in place. They will run the affairs of that trust. In the event of your demise, they again will identify and disclose your desires or your instructions as to how your estate is to be run. So yes, both the trustees and perhaps the professionals that were used in the drafting of your will are obligated to disclose that to your family members at their appropriate time. Thank you.
Thank you, Jackson, for that. Thank you, Martin, as well, for helping out in responding to the questions that are coming through. There's a lot of activity around this topic, and maybe we might want to consider having another session just to ensure that we are more clear on all the areas of estate planning. So we plan to have many other forums, educational forums, with you as our customers that even go beyond the products that you hold with us, to ensure that at any one point you have peace of mind. And this, of course, aligns with our purpose as a company of safeguarding your dreams and aspirations. So should you wish to engage us further on this topic, we request that you send through your queries and clarifications through the email address that is on the screen, pensionsqa@britam.com, and the team will be on standby to be able to respond to you. Should you also have any suggestions on any areas of life that you'd want us to educate you more on, please feel free to air those suggestions, and we'll be willing to have an expert carrying out that exercise so that we are all informed. So with that, we have come to the end of the session. I will lead you in a closing prayer. And before then, I want to thank all of us for finding the time to join us today. We really appreciate that. And we hope that even going forward, that we shall have more and more engaging sessions as we have had today. With that, please allow me to lead you with a closing prayer, after which you're free to leave the session. Thank you. Almighty God, we come again to you to thank you for leading us through this session and making it a success, making it impactful to us all who are participating in this session. We pray, Lord, that you may guide us to ensure that we are well prepared for any potential transitions, to avoid, to ensure that even going forward, our families or even our businesses continue as we plan. We thank you and we glorify your name, and we pray, Lord, that you may guide us even for the remaining day, that you may protect us and keep us. We thank you and glorify your name. May your name be blessed. May your name be glorified. And we pray this in Jesus' name. Amen.
Amen.
Thank you. Have a nice day.
Thank you.